All right, hi and welcome back. Attorney Steve Vondran here. Welcome to another exciting video dealing with the topic of internet file sharing, torrent defense. Okay, so this is a case, if you've been following my channel, I talk about these Strike 3 holdings cases, Malibu Media, and we talked earlier in another video about the Cobbler case. The Cobbler case came down, and that was Ninth Circuit Court of Appeals, and the Cobbler case said, look, if you can't allege something more than a person is guilty of movie downloads because they're the internet subscriber, if you can't allege something more than that, you know, your pleading is fatal. Your pleading could be subject to a motion to dismiss. So this is what we're dealing with here. Now, in this case, this is a case from, as you can see here, the Eastern District of California, the Eastern District. Here's your case number up there in case you're looking for it. But this is good to know. Now, some people will say, you know, why don't we file a motion to quash? Well, this is kind of the reason here. A motion to quash being a motion to quash the subpoena so they can't get your information from the ISP. So some people say, well, why don't you file a motion to quash? And here's the real reason is because for the most part, unless you can hit one of the grounds that we'll talk about in a second, it's not going to work. For the most part. Okay, again, this is not legal advice. This is general legal information only. But here we have presently pending before the court. This is another John Doe lawsuit. They sue the John Doe. All they have is an IP address, and they want to track that back into somebody's house and say, well, Joe Schmo is the infringer because Joe Schmo is the internet subscriber. Well, that's not always the case, and many times it's not, by the way. So here we are. Defendant in this case said, you know what, I'm going to file a motion to quash. I'm going to talk about that Cobbler case that came down. Where do we have that? Where's Cobbler? Let's come down here. Here we have the Cobbler Nevada case. You can see it right there, Cobbler Nevada, okay? And talks a little bit about it right here, Cobbler Nevada. So this was the big case that came down. In the motion to quash, first off, the court talked about the legal standard on a motion to quash. You got to fit into one of these grounds right here. And I should have highlighted these up here too, but in order to win on a motion to quash, you have to be able to show a court must quash or modify a subpoena that, one, fails to allow a reasonable time to comply. Well, usually the ISP gets all kinds of time to reply, so that's not a problem. Two, requires a person to comply beyond the geographical limits specified in Rule 45. Three, requires disclosure of privileged or other protected matter if no exception or waiver applies. Or four, a lot of people have tried this, subjects a person to undue burden. And usually the courts say, well, the burden is on the ISP, not the person, so don't worry too much about that. Additionally, here's a couple other grounds. A district court may quash or modify a subpoena if it requires disclosing a trade secret or another confidential research, development, or commercial information, or disclosing an unretained expert's opinion or information that does not describe specific occurrences in dispute and result from the expert study that was not requested by the party. As it notes here, the party seeking to quash has the burden of persuasion. So if you're going to seek a motion to quash, you got to explain to the judge one of these grounds and why it makes sense. So in this case, the defendant said, well, look, Judge, we had the Cobbler Nevada that said merely naming somebody as an internet subscriber doesn't mean they're an infringer. So since the case is probably going to be subject to a motion to dismiss, why not just quash the subpoena? And the court said, no, these are two different motions. On a motion to quash, you got to find one of those grounds. But it noted here, accordingly, following Cobbler Nevada, district courts in the Ninth Circuit have continued to allow plaintiffs to subpoena ISPs for defendants' contact information, reasoning that the defendant's defenses to the claims are more properly reserved during a later stage motion to dismiss. So the court's still saying, hey, how about that motion to dismiss? That may be something for you per the Cobbler case, but the quashing, trying to quash on the strength of the Cobbler Nevada case doesn't look like it's going to get much traction here. Okay, so that's what this case stands for. Now, Coming down here, what the court is saying, while any of these defenses may prove to be true at this juncture, plaintiff is simply attempting to ascertain the subscriber's identity. Thus, defendant's reliance on Cobbler Nevada case versus Gonzalez to preclude discovery based on factual innocence is misplaced. Indeed, in Cobbler, the district court permitted the plaintiff to subpoena the ISP for the defendant's information, conduct an initial investigation, so forth and so on. So the court's saying you're citing Cobbler, but even in Cobbler, the Ninth Circuit case, the courts allowed the subpoena to go through so that the defendant, so the plaintiff could try to figure out the identity of the alleged infringer. So, court's saying, this isn't quite the right setting for that. Here's some more information if you want to pause and read that. I'll let you take a look at that. Otherwise, I'm going to move on. And then again, to the extent that defendant alleges factual innocence, such a consideration is premature and may be raised in a motion to dismiss. So that seems to be what the courts are looking at here, at least the Ninth Circuit where I practice, where I handle these illegal movie download cases, so forth and so on, copyright infringement. But here you have it. Now, one other piece that I really liked in this, and you may want to point this out sometimes, is look, the court also advises plaintiff. That's the plaintiff, okay? Strike 3. Maybe it's Malibu Media in another case. Could be another case dealing with torrents. That upon obtaining the name and address of the DOE defendant, so they get the name and address, plaintiff has a Rule 11 obligation to determine whether to proceed with the lawsuit, and in that regard, it should be mindful of the Ninth Circuit's recent holding, and this is the Cobbler, that a bare allegation that a defendant is the registered subscriber of an Internet Protocol IP address associated with infringing activities is insufficient to state a claim for direct or contributory infringement. There's your case law. There's your Cobbler Nevada 901, Federal 3rd, 1144, bingo. So what the court's saying, and I'm going to post the Rule 11 right down here for you, but basically the Rule 11 says you got to have a good faith belief that you have sued the right person. It can't be just designed to harass somebody and say, well, I'm going to sue the subscriber and force them to tell me everything. The court is suggesting that that could be improper and subject to Rule 11, which is sanctions. You can seek sanctions for a plaintiff counsel that is violating this rule, this federal rule, okay? So that's this follow-up case on a motion to quash, trying to use the Cobbler Nevada case unsuccessfully, but the court leaving open the option that these cases may be ripe for a motion to dismiss, and cautioning the plaintiff that there is Rule 11 and don't just name somebody just to name somebody, okay? So there you have it. I hope you enjoyed this video. This should help if you're in the trenches dealing with a company trying to get thousands and thousands and thousands of dollars out of you for some movie downloads, okay? If you need help, you know where to find us. We are a leader in this area of law. We've been helping lots and lots of people. We have lots of great reviews. And you owe it to yourself to give us a ring, see what we can do for you, discuss your options. You can find us on the web at attorneysteve.com. Attorneysteve.com. Let me ask you, what other attorneys out there are bringing you this kind of general information so you understand the process and then you understand what's going on? Listen, if you like this video, give me a thumbs up. Let me know that you like me working hard, showing you guys what's going on in our legal system, giving you some ideas and things like that. So I appreciate it. You know where to find us. Copyright Civil Litigation at attorneysteve.com, the first name in legal services. I got to run. I got a nice video coming up next. Make sure to subscribe. I've got a case on a video coming up on copyright small claims court. You didn't know about this, did you? Could be coming your way soon. So I'm going to be doing a video on that. Make sure to subscribe. Thanks a lot. Have a great day, everybody. We'll talk again. Attorney Steve out.